A union is a democratic organization of employees in a workplace who choose to join together to achieve common goals. By forming unions, employees can work collectively to improve working conditions, including wages and benefits, hours, and job safety, to resolve disagreements of employees and employers, and to find the best ways to get the work done. Unions also represent members and all people who work by advocating work-family friendly laws and policies through legislative and political action. Most people who work in this country have the right to form and join unions under the 1935 National Labor Relations Act, which encourages union formation. In 1935, Congress passed the National Labor Relations Act to encourage a healthy relationship between private sector workers and their employers. Prior to the National Labor Relations Act, employers were not required by law to recognize a union or to bargain in good faith. By establishing employees' basic rights to join unions and engage in collective bargaining, Congress hoped to reduce work stoppages, strikes, and other conflicts between labor and management that had all too often resulted in violence. The Act also created the National Labor Relations Board as the organization to enforce the National Labor Relations Act. The National Labor Relations Act accomplished three significant objectives. First, it allowed workers to have elections to decide if they wanted to be represented. Two, it established laws protecting employees from discrimination based on union or group-related activity. And lastly, it created the National Labor Relations Board as an administrative organization to enforce the law. The National Labor Relations Act forbids employers from interfering with, restraining, or coercing employees in the exercise of rights relating to organizing, forming, joining, or assisting a labor organization for collective bargaining purposes, or from working together to improve terms and conditions of employment, or refraining from any such activity. Similarly, labor organizations may not restrain or coerce employees in the exercise of these rights. Some examples of employer conduct that violates the law. First, threatening employees with loss of jobs or benefits if they join or vote for a union or engage in protected concerted activity. Two, threatening to close the plant if employees select a union to represent them. Three, questioning employees about their union sympathies or activities in circumstances that tend to interfere with, restrain, or coerce employees in the exercise of their rights under the Act. Four, promising benefits to employees to discourage their union support. Fifth, transferring, laying off, terminating, assigning employees more difficult work tasks, or otherwise punishing employees because they engaged in union or protected concerted activity. And lastly, transferring, laying off, terminating, assigning employees more difficult work tasks, or otherwise punishing employees because they filed unfair labor practice charges or participated in an investigation conducted by the National Labor Relations Board. Some examples of labor organization conduct that violates the law. First, threats to employees that they will lose their jobs unless they support the union. Two, seeking the suspension, discharge, or other punishment of an employee for not being a union member, even if the employee has paid or offered to pay a lawful initiation fee and periodic fees thereafter. Three, refusing to process a grievance because an employee has criticized union officials or because an employee is not a member of the union in states where union security clauses are not permitted. Four, fining employees who have validly resigned from the union for engaging in protected concerted activities following their resignation or for crossing an unlawful picket line. Fifth, engaging in picket line misconduct such as threatening, assaulting, or barring non-strikers from the employee's premises. And lastly, striking over issues unrelated to employment terms and conditions or coercively and mentioning neutrals into a labor dispute. So what rules govern collective bargaining for contracts? After employees choose a union as a bargaining representative, the employer and union are required to meet at reasonable times to bargain in good faith about wages, hours, vacation time, insurance, safety practices, and other mandatory subjects. Some managerial decisions, such as subcontracting, relocation, and other operational changes, may not be mandatory subjects of bargaining, but the employer must bargain about the decision's effect to unit employees. It is an unfair labor practice for either party to refuse to bargain collectively with the other. but parties are not compelled to reach agreement or make concessions. If after sufficient good faith efforts no agreement can be reached, the employer may declare impasse and then implement the last offer presented to the union. However, the union may disagree that true impasse has been reached and file a charge of an unfair labor practice for failure to bargain in good faith. The National Labor Relationship Board will determine whether true impasse was reached based on the history of negotiations and the understanding of both parties. If the agency finds that impasse was not reached, the employer will be asked to return to the bargaining table. In an extreme case, the National Labor Relations Board may seek a federal court order to force the employer to bargain. If the agency finds that impasse was not reached, the employer will be asked to return to the bargaining table. In an extreme case, the National Labor Relations Board may seek a federal court order to force the employer to bargain. The parties' obligations do not end when the contract expires. They must bargain in good faith for a successor contract or for the termination of the agreement. While terms of the expired contract continue, a party wishing to end the contract must notify the other party in writing 60 days before the expiration date, or 60 days before the proposed termination. The party must offer to meet and confer with the other party and notify the Federal Mediation and Conciliation Service of the existence of a dispute if no agreement has been reached by that time. So how is good faith bargaining determined? There are hundreds, perhaps thousands, of National Labor Relationship Board cases dealing with the issue of the duty to bargain in good faith. In determining whether a party is bargaining in good faith, the board will look at the totality of the circumstances. The duty to bargain in good faith is an obligation to participate actively in the deliberations so as to indicate a present intention to find a basis for agreement. This implies both an open mind and a sincere desire to reach an agreement, as well as a sincere effort to reach a common ground. The additional requirement to bargain in good faith was incorporated to ensure that a party did not come to the bargaining table and simply go through the motions. There are objective criteria that the National Labor Relations Board will review to determine if the parties are honoring their obligation to bargain in good faith, such as whether the party is willing to meet at reasonable times and intervals, and whether the party is represented by someone who has the authority to make decisions at the table. Conduct away from the bargaining table may also be relevant. For instance, an employer were to make a unilateral change in the terms and conditions of employees' employment without bargaining. That could be an indication of bad faith. So what are the rules about the union dues? The amount of dues collected from employees represented by unions is subject to federal and state laws and court rulings. The National Labor Relations Act allows employers and unions to enter into union security agreements which require all employees in a bargaining unit to become union members and begin paying union dues and fees within 30 days of being hired. Even under a security agreement, employees who object to full union membership may continue as core members and pay only that share of dues used directly for representation, such as collective bargaining and contract administration. Known as objectors, they are no longer full members, but are still protected by the union contract. Unions are obligated to tell all covered employees about this option, which was created by a Supreme Court ruling and is known as the Beck right. An employee may obtain to union membership on religious grounds, but in that case must pay an equal amount of dues to a non-religious charitable organization.